This is where I think the prosecutor actually did a good job today. He put it out in print for the jury to read. I teach trial skills to Harvard Law students, and one of the things that I always speak about is that you have to be clear, and I advocate for the use of a PowerPoint. So when the prosecutor did it, I was surprised, and I think that speaks well for him, though, as I mentioned, his earlier errors may still free Rittenhouse. And how you craft that verdict sheet is very important, because if it's not clear, the jury's going to get confused, and they may inadvertently vote one way when they think they're voting another way.
To break down some of what happened today, I want to bring in criminal defense attorney Vinoo Varghese. Vinoo, thanks for joining us here on Live Now.
My pleasure, Daytona, my pleasure.
Okay, so Bill, at the end of that story, talking about some of those charges that were dropped today, did anything come as a surprise to you?
Well, I wasn't aware that the misdemeanor charge was going to get dismissed. In fact, at the beginning of this, that seemed to be the underpinning of the case, that Rittenhouse shouldn't have been there. He's underage. It's not lawful for him to carry a weapon in Wisconsin. But that got dismissed. That being said, let me talk about the prosecutor's summation today. I thought he actually did a very, very good job. I am a former prosecutor, but I've been a criminal defense. That was eons ago. That was a very, very long time ago. I've been a criminal defense attorney 16 years. I was a prosecutor for 6 before that. I'm critical of prosecutors. That's what I do for a living. But he gave a very clear and detailed and well presented summation, closing arguments. Now, the problem for him is that the jury, maybe many of them have their minds made up. So often summation doesn't move the needle, but sometimes if you've laid everything out, you can then summarize it in a way that's clear. And he used a PowerPoint, which is kudos to him. A lot of prosecutors at the state level don't often use PowerPoints. He did. Federal level, it's common, and it's common for really good lawyers to use it. The bad lawyers don't, because you have to connect with the jurors. They have to hear it, they have to see it, they have to feel it, they almost have to smell and taste it as well. So the fact that he did and he laid out his arguments very clearly, I thought was good. Now, whether it's too little too late, we'll see. But I think that dropping that charge was a problem for them.
Well, so we've been talking mostly about the prosecution. What about the defense? What were your thoughts on their end, as their main goal in all of this is to prove that Kyle Rittenhouse was using self-defense?
I wasn't so thrilled with their summation. And I'll tell you why. They brought up a point which I found puzzling, which was the point about Jacob Blake. Now, Jacob Blake was the man who was shot 7 times by an officer, as you know, and what set off these particular set of riots or looting and arson, whatever the judge said, the words that the defense can use. But he brought up a point that said sometimes you can shoot someone 7 times and get away with it. Well, the shooting of Jacob Blake was legally justified. I mean, Jacob Blake came at a cop with a knife. The cop had every right to shoot him. And that's the bizarre thing about all of this, that if there was a person to go to bat for, it wasn't Jacob Blake. And I know LeBron James didn't understand that, but this is one of those things that, that's not the guy you kind of refer to, because people who understand that will go, wait a minute. Jacob Blake was a legally justified shooting, so why are you saying the cop got away with it? Well, maybe we shouldn't let Kyle Rittenhouse get away with this, because when you look at it, what's underlying this case is, why was he there, right? Now, as far as the legal justification of whether he's justified, in other words, was it lawful? Was it proper for him to shoot these people? It's a 2-pronged test. It's the subjective objective test. And I'm going to take you back to something I learned in law school. And it actually comes from history books. The Bernie Getz case in New York. And it established this test, which has basically been adopted by courts and states all around the country. So it's basically that one, subjectively, Rittenhouse had to fear for his life. But then the juror can look to see whether that behavior was objectively reasonable. And so when you look at the first person that he tangled with, Rosenbaum, was it reasonable? Rosenbaum, let's take a step back here. Did Rittenhouse actually think he was in danger? When Rosenbaum chased him, well, he's the one with the gun. He said Rosenbaum didn't have a gun, and that, as it turned out, Rosenbaum threw a plastic bag at him. So in my view, I'm not sure if he subjectively believed that he was in danger, but let's assume for a second that he did, and the jury accepts that. Was it objectively reasonable to shoot Rosenbaum? And then what's also behind all of this is whether you can claim self-defense. Well, under Wisconsin law, you can't do so if you were the aggressor. And it appears the other two people who were shot, one of whom was killed, were trying to stop what they believe was an active shooter at that point. So you can't claim self-defense if you were the initial aggressor, which is in line with most states, which is in line with what I deal with here in New York. So there are a lot of problems for Rittenhouse. And then when you take into consideration his crying on the stand, there's two ways to look at that. Either that's going to evoke sympathy, or you're going to say, is this guy for real? This is Mr. Tough Guy with the AR-15, and he's crying like a baby on the stand. Is he crying because he's sorry? He didn't sound remorseful. He sounded like, he's caught and he's upset. And the jurors may look at that. Particularly today, the AP News reported that jurors winced when they saw the pictures of the dead body. They winced when they saw the third guy who survived had his bicep blown off. So the jurors may look at this and go, there was no reason for him to be there. I don't believe or give him credit for believing he was subjectively in danger. And then even if he thought he was so because he's 17 and whatever, it wasn't reasonable to shoot an unarmed man who had a plastic bag. It's not reasonable when you have the AR-15 and who has his hands up. So Rittenhouse, I think, has some problems here, but the prosecution may save him. And here's why. They committed a number of errors, one of which is a colossal legal error during a trial. You cannot comment on a defendant's right to remain silent. And so the prosecutor, and this was talked about in a lot of the papers, the prosecutor brought up the fact that he remained silent after the shooting. Well, that's his constitutional right. And that is normally reversible error. And the judge yelled at him, the prosecutor, and the defense moved for a mistrial. So what may happen here, the judge denied it. And I think the judge is thinking, let's play this out. There's probably going to be an acquittal. If there is, well, then I'll grant the mistrial. So that could be what's going on behind the scenes, but we'll know soon enough.
Yeah, Vinoo, I want to go back into some of what the jury is facing right now. You mentioned that some of them winced today in court when they saw some of those photos. And mind you, this is after hours upon hours of closing arguments. You can only imagine how tired and exhausted all of these members are. But what about the actual charges? Can we talk about that? Because there's been so many counts that have been pulled out and so many things that have changed throughout the duration of this trial. So how do you explain to a jury full of what is supposed to be average Americans the small words that make a massive difference on whether or not he should be found guilty or not guilty?
This is where I think the prosecutor actually did a good job today. He put it out in print for the jury to read. And this is was a sort of almost clinical way of trying to convince the jurors what they should vote for. I teach trial skills to Harvard law students. And one of the things that I always speak about is that you have to be clear. And I advocate for the use of a PowerPoint. So when the prosecutor did it, I was surprised. And I think that speaks well for him, though, as I mentioned, his earlier errors may still free Rittenhouse. There are a number of charges, including reckless homicide, intentional homicide, and then a number of lesser charges that the judge agreed to submit. So they can go in, and I bet you the verdict sheet is sort of like a little puzzle. If guilty, check. Then go to the next one, check. You may not have to go down, because if you find him guilty of the top counts, you may not need to consider the lesser counts. But if not guilty, go down. Here, guilty, not guilty. If not guilty, go down. So the prosecutor has a bunch of options available to him. And how you craft that, that's called a verdict sheet, by the way. And how you craft that verdict sheet is very important, because if it's not clear, the jury's going to get confused, and they may inadvertently vote one way when they think they're voting another way. But at the end of a trial, the judge can poll the jury, which is question each individual jury as to each count as to whether he or she voted that way. But by that point, it's very unlikely that a juror is going to change his or her vote. So there are a number of charges which gives the prosecutor options. I think the defense throughout the trial, I think, did a decent job, but I wasn't particularly impressed as I was watching today during their summations.
Vinoo, just a couple more questions for you. We appreciate you breaking all down for us. One thing that caught all of our attention was the tension between the judge and the prosecution today. There were some actual objections about the defense on the state's rebuttal. This was regarding some of the prosecution statements in front of the jury when they were speaking about Joshua Ziminski. He was one of the guys who fired a gun in the air before Rittenhouse ultimately opened fire. What have your thoughts been throughout this trial of some of those tense moments between the prosecution and the defense and the judge as well?
Well, the reality is that most judges around the country, the overwhelming majority of them, are pro-prosecution judges. It's very rare. It's rare when you see a judge that's defense-oriented. And I'm not sure in this case a judge is defense-oriented, but I think here the prosecutor, who seems to me to be a very intelligent man, who actually gave I thought was a very well laid out summation, as I mentioned, getting angry correctly at this prosecutor, because I think this prosecutor probably read all the hype and thought he was going to lose instead of looking at this logically. And this is a winnable case for the prosecution, but he probably heard all the hype and then decided to give in to his worst instincts and forget basic American constitutional law that a person has a right to remain silent, and you can't comment on it if he does. Now, that was pre-trial. Now, once he testifies, he no longer has that presumption that he's given up that right to remain silent. He's given up the right to remain silent, and now you can evaluate him like any other witness. If he hadn't testified, then the jury can draw no negative inference from him not testifying. But now that he's testified, they can look at him and go, yeah, I like this guy, I don't like this guy. And I'm not sure that Rittenhouse really came across that likable. And a lot of times this goes down to likability, believe it or not. Jurors are like, no, I like him, I don't like him, and they may vote one way or another. And it's always about emotion. Yeah. You're supposed to be devoid of emotions, but you've got to tap into that one way or another. And the defense, I think, argued from a point of emotion, though some of the things they said today were a little bit puzzling. But I think the prosecutor did a good job, and particularly tapping into the emotion when he showed the pictures. And also, and you got to wonder, they've seen these photos already. So the fact that they're still wincing at this point is not good for the defense. But he also said something else that really I thought was powerful. And this was right at the beginning. He said, you don't want 17-year-olds walking around becoming just trying to dispense justice with guns, with AR-15s. I think most people, whatever you believe in terms of gun rights or not gun rights, you're probably like, yeah, that he's not the right person to be patrolling the streets. And I think that probably struck a chord with a number of jurors. And he also did a really good job insulting this guy. Throughout the summation, he called him a cop wannabe. Those kind of things stick out. And there wasn't anything that the defense said today that I remember, other than the comment that somehow the cops shouldn't have gotten away with shooting Jacob Blake, which is mind-boggling.
Well, with all of that being said, Vinoo, what are your expectations going into tomorrow and possibly Wednesday?
Well, I had initially I had predicted on another network today that I thought he was going to get acquitted of all counts because of the way that it was going. But as the day went along, I watched the prosecutor's summation, understand it may be too little too late at this point, but I thought he did such a clear job. And then the reports that I'm reading about some of the jurors and the reactions. Now, we can watch the summations and the back and forth between the judge and the lawyers, but we're not seeing the jurors. Obviously, they are being protected as they should be, so we can't see their reactions. But when I read the AP reports about their reactions to this, I said to myself, how is it that they're affected by this, even after seeing these photos over and over again? So I don't think that bodes well for Rittenhouse, and it wouldn't surprise me if he's convicted of several of the charges. All
right, Vinoo Varghese, criminal defense attorney, former prosecutor. We got all the bases covered. Thank you so much for coming on and breaking it all down for us.
My pleasure.